This is a case review of an international law case for Class ATE 3515, Legal and Ethical Issues in Veterinary Technology, St. Petersburg College, Fall Semester, 2018, by Rebecca Ferguson, RVT. This case was heard by the Honorable Mr. Justice W.E. Wilson in Edmonton, which is the capital city of the Alberta province in Canada. Alberta Court of Queen's Bench on Friday, June 19, 1998. This was a tort case pertaining to the civil practice and procedure of the province. The plaintiff, Cheryl Tulloch, was suing the defendants, Peter and Gladys Melanchek, for damages incurred when the defendants shot her valuable canine. Initially, there were two complaints presented to the judge. One, the defendants sought damages for the trespass to chattels. Ultimately, the defendants dropped this countersuit. And two, the plaintiffs requested for damages for the loss of the canine. Merriam-Webster defines chattel as an item of tangible, movable, or immovable property, except real estate, and things such as buildings connected with real property. On the morning of September 7, 1998, Ms. Tulloch's canine was let out of the house by a friend. The defendant, Mr. Peter Melanchek, shot the canine with a firearm that resulted in the death of the canine. These are the facts of the case. Ms. Tulloch's canine was let out of the house by a friend. The canine was not in a fenced property, as attested to by a neighbor that gave testimony, and the canine ran off the property. The plaintiff spent an undetermined amount of time with the friend looking for the canine after it had taken off. The canine was found deceased on the plaintiff's property. The defendants had a broken fence due to the cattle. The defendants' cattle were no longer properly contained. The canine in question was seen in the pasture harassing the cattle. There were three sets of evidence in this case. The first is the general evidence. The two parties lived on adjacent parcels of property. The Melancheks were producers operating a cow-calf operation, and Ms. Tulloch raised dogs on a small parcel of land that she rented, which did not support any external form of containment for the canines. The evidence for the plaintiff. Ms. Tulloch testified that she only heard one shot fired the date of the incident. She also cited several verbal conversations with the defendants earlier that morning and the week following the incident. Evidence for the defendant. The veterinarian who examined the canine post-mortem testified it had been shot once with a projectile entering the face with a lack of an exit wound. Testimony of the plaintiff and her friend left no doubt that the dog was not properly contained. Two neighbors testified to the damages to the fence and assisting with the subsequent recapture of the loose cattle. A third neighbor testified to having previously seen the dog unconfined. Mr. Melanchek claimed to have fired a warning shot prior to firing the fatal shot. The defendant's attorney argued that the incident violated the Stray Animals Act. I was able to locate a more recent version of the Stray Animals Act from 2000. This is a revised statute of Alberta, which was printed in 2010. Section 25 gives the permitted right to kill a dog. The section states the owner or the person in actual possession of livestock or domestic fowl or any person authorized by either of them may kill a dog in the act of pursuing, worrying, or destroying that livestock or domestic fowl on land owned or occupied by the owner or person in actual possession of the livestock or domestic fowl. Author James Wilson of our textbook defines direct evidence as information provided by persons who witnessed an occurrence with their own ears, eyes, noses, and other senses. Therefore, the primary issue with this case is the credibility of the testimonies submitted by the defendant, the plaintiff, as well as the testimonies of the witnesses on the day of the incident. Though the judge did express his sympathies to the plaintiff, he ultimately dismissed the case. The judge determined the facts presented met the qualifications for the Stray Animals Act. The judge determined from the testimonies of the conversations between the parties, it was clear that these conversations did not occur and that Ms. Tulloch was not in sight of the defendants upon the time of finding the deceased canine. The judge also determined that the canine's actions met the definition of harrying, worrying, and chasing the cow, and that a bite was not necessary. The judge felt that the actions of Mr. Melanchek were sufficient to deter the canine, and since it did not, the defendant was justified in his actions. This was further corroborated by the fact that the cow was on the defendant's left and the canine was on his right, and he shot the canine in the head, opposed to being shot in a position in which the canine was retreating. He stated, "The whole picture here is that the dog was chasing and continuing to worry this cow at a critical time, as the cow was lame, and the farmer need not wait until the fangs are sinking into the flesh before exercising his rights under the Stray Animals Act." Judge Wilson went on to cite an appellate case to support his decision. Cresswell v. Cyril of 1948 was a case in which a defendant shot and killed a canine that was harassing sheep. This is my analysis of this case. I was unable to find any dissenting positions. I agree with Judge Wilson that the defendant had a right to protect his property that was legally contained. I have seen several canines in emergency clinics that have been shot by livestock owners that had been harassing the livestock. In these instances, it is apparent based on the injuries to the animal when it was a case where the canine was attacking position or in a retreating position based on their injuries. I found further support in the case of Cope v. Sharp, 1912, case 1 KB 296. This is another Canada case that was determined by a jury trial, which proved a theory of defenses to assault warranted trespass in order to prevent loss of personal health, prevent fire, and subsequent loss and damage to property. This case proposed 4 positions that defend the actions of shooting a canine. The dog in question is attacking the animals in question. 2, if left, the dog would continue to attack. 3, there are no practical means to stop the canine. And 4, the defendant acted reasonably under the circumstances presented. I also found the Local Government Act of British Columbia, which is a neighboring province, enacted in 1996, which is also a revised statute, would have been a valid argument for the defendant's countersuit, as it states under Section 25 that everyone that commits an offense who is willfully kills, maims, wounds, poisons, or injures cattle, or places poison in such a position that it may be easily consumed by the cattle, may be subject to punishment for a fine up to $10,000 and or imprisonment for up to 18 months. As shown by my photographs, my family has a strong agricultural background. My grandfather was a World War II veteran that later owned and operated a small dairy, and my brother-in-law owns and operates a cow-calf operation. As such, I have great sympathy for both parties in this case. However, it was an entirely preventable situation on the part of the plaintiff, and I agree with Judge Wilson's decision. Aside from that, I also own a herding dog that loves to herd my sister's chickens, neighbors' sheep, as well as the cattle. So I completely understand the need to have a dog that is under close supervision around these animals, as well as having the ability to do verbal recall or keep them contained to ensure the safety of the livestock. Thank you. These are my sources for my presentation. I appreciate any feedback and look forward to discussing the case with you guys moving forward. Have a good weekend.